Let's talk about the U.S. Supreme Court's decision in Grants Pass, Oregon versus Johnson. This was from back in June, so it's a little while ago, but I think it's an important case. This was another 6-3 decision, all 6 conservative justices joining the majority, Justice Gorsuch writing the majority opinion, as well as a concurrence only from Justice Thomas, and then a dissent written by Sotomayor, joined by Kagan and Jackson. So, Grants Pass, Oregon versus Johnson. Did this case pave the way for a war on homeless people in the states and localities? Well, let's talk about it, and let's talk about the legal reasoning used by both the majority and the dissent. So Gloria Johnson and John Logan were the plaintiffs. They sued. The Ninth Circuit had this case called Martin versus Boise, where they considered a public camping ordinance in Boise that made it a misdemeanor to use, quote, streets, sidewalks, parks, or public places, end quote, for camping. The Ninth Circuit held that this violates the cruel and unusual punishments clause of our 8th Amendment. And so after Martin, there were a bunch of similar suits against these types of ordinances in the Ninth Circuit. And they had what they call Martin injunctions against the ordinances that were said to violate the cruel and unusual punishment clause in the Ninth Circuit. And this is one of those cases. So there's about 600 homeless people in Idaho. The ordinance was never actually enforced against the plaintiffs, but they're representing a class. And so the way that it works, the ordinance has 3 major provisions that are relevant here. First, no sleeping on sidewalks, streets, or alleyways in public, no camping on public property, and no camping and overnight parking in the city's parks. So camping also could sometimes be including a vehicle, so sleeping in your car, sleeping on your motorcycle. So the penalties for violating these basically escalate stepwise. Initially, it starts off with a fine. Then after the fine, you can be subject to an order that prohibits you from entering the city's parks for 30 days. And if the people violate that order, then they can be subject to a $1,250 fine or a maximum of 30 days in prison. So notice with these ordinance provisions, the text of them does not mention homeless people at all. It just says people. So they are indiscriminate. They're neutral, seemingly. They're what they call generally applicable. That's a term that the courts use a lot. So this is something that's going to be really important to the Supreme Court going forward. So the district court enjoined the city, that's to say it prevented them from enforcing their public camping laws against the homeless. The Ninth Circuit agreed. So that's why Grants Pass is the petitioner here. They lost in the lower court. So this gets up to the Supreme Court. So Justice Gorsuch writes that the punishments that Grants Pass imposes are not cruel and unusual. He starts off by talking about the history of the 8th Amendment and the way that it usually applies just to punishments, not to what you punish. So obviously a punishment like burning someone alive or disemboweling them, that's obviously cruel, that's obviously unusual. And our founding fathers, with their enlightened values, did not want to have that type of punishment in our country, correctly so. So yeah, obviously they're not punishing people who violate this ordinance in that way. But then he brings up the case of Robinson versus California. And in Robinson versus California, the Supreme Court in 1962 addressed a criminal conviction under a California statute that provides that no person shall be addicted to the use of narcotics. And the court held that California could not enforce its law making the status of narcotics addiction a criminal offense. So while imprisonment for 90 days was not a cruel and unusual punishment in the eyes of the Robinson court, putting someone based on their status as a narcotics addict in prison for even 1 day was cruel and unusual. So cruelness and unusualness doesn't just apply to the punishment. It applies to the things you're punishing. So in Robinson, the court held that they were punishing status. And to punish status, even with something as brief as 1 night in prison, is cruel and unusual punishment. So Gorsuch writes that they're not going to reconsider Robinson. By criminalizing a status, the state of California took a historically anomalous approach toward criminal liability that's never been encountered since Robinson itself. So never in the 62 years since then. So he's saying, yeah, it's really rare to criminalize status. We haven't had that in 62 years. He points out that we're not going to extend Robinson to this case. We've rejected the idea of extending Robinson, he says, in the case of Powell versus Texas. And that brings in our second main case here, where the justices kind of do compare and contrast. So Powell versus Texas was 1968, 6 years after Robinson. It was written by Justice Thurgood Marshall, very progressive guy, which involved a statute criminalizing getting drunk or being found intoxicated in a public place. So the Powell court argued that Powell, the petitioner, argued that Texas criminalized his status as an alcoholic. And so Marshall's opinion held that Robinson does not reduce a state's power to secure a conviction when the accused has committed crime or some act that society has an interest in preventing. And this is true regardless of whether the defendant's act might be involuntarily caused by a particular status. So the fact that this guy is an alcoholic is not being criminalized. He's free to be an alcoholic on his own public property, maybe at his friend's house or something, at his own house. But he can't go out and get drunk. It's a pretty draconian law when you think about it. But yeah, so they weren't criminalizing status in that case. They were criminalizing the act of going out in public and being drunk. So Gorsuch writes, this case is no different from Powell. He writes that there are dangers in extending Robinson to involuntary acts. If the court pursued that path in the name of the Eighth Amendment, the court could become an ultimate arbiter of standards of conduct in criminal responsibility in diverse areas of criminal law throughout the country. So, yeah, do you see the problem here with saying that this case is perfectly analogous to the case of Powell versus Texas? Hold that thought. We're going to get to the dissent. But first, Justice Gorsuch says that the dissent accuses us of giving local governments and states unfettered freedom to punish. So how does he rebut this accusation? He says, this is wrong. States and cities are not bound to adopt public camping laws. They can choose narrower laws. So that doesn't address the criticism. He's not addressing the criticism here. Just because the states and the local governments have power to do less doesn't mean that they haven't been given too much power by this decision. You're just giving them massive amounts of discretion. Now, obviously, there would be some point where all of these justices, I assume, would probably draw the line, but you're not explaining exactly where the line is. I mean, he thinks it's Robinson versus California. Clarence Thomas doesn't. But arguably, this case is more similar to Robinson versus California than it is to Powell versus Texas. So, as I said, Thomas in his concurrence says, actually, I agree with the judgment, but I think that we should consider Robinson versus California again, and that we should overrule it. He thinks it was poorly decided. It was wrongly decided based on the idea of modern public opinion, and that modern public opinion is not a valid means of interpreting the U.S. Constitution. Then we get to Sotomayor's dissent. She says, the city, plain and simple, is just punishing people for being homeless. This is status punishment. They're jailing and they're fining people for sleeping anywhere in public at a given time. Sleep is a biological necessity. They're even punishing them for sleeping in their cars if they use as little as a blanket to keep warm or a rolled up shirt as a pillow. People become homeless for reasons that are outside of their control. So it's an involuntary thing. There aren't just people saying, I don't want a home. I'm too cool for that. I'm going to go camp out in the parking lot or something. So Robinson, she writes, was not limited to narcotics addictions. The majority doesn't seem to dispute this. It also didn't rely on the harshness of the criminal penalty imposed. We've repeatedly cited, Sotomayor writes, Robinson for the idea that the Eighth Amendment imposes a substantive limit on what can be made criminal and what can be punished. The majority is wrongly treating it as an outlier. So they disagree about the significance of Robinson. But here I think is where the meat of what the dissent's saying is coming in. Powell involved a statute that criminalized voluntary conduct that could be rendered involuntary by status. But in this case, the ordinances criminalize conduct that defines a status. And I mean, she's largely right. If you're homeless in the city of Grants Pass, Oregon, you kind of have very little choice but to sleep in public. Your only other choice would be to ask someone who owns private property if you could sleep on their private property. Get someone to have a sleepover with or something. So yeah, it's disappointing, I would say, that the majority doesn't even address this. They don't even address the little choice that homeless people have. They didn't need to extend Robinson, but they certainly shouldn't have treated this case as though it was analogous to Powell. So by ignoring this crucial point, it seems that the majority really has just enabled states and local governments to pursue some very draconian policies against homeless people. I don't think it's sensationalistic to say that they've incentivized some very harsh policy. Maybe not as far as total war on homeless people, but really, where are they going to draw the line? I mean, the text of the statute, as I point out, it's neutral. It applies to backpackers or anyone, but to people who have a home, a shelter, they can just sleep there. Homeless people have no choice but to violate this statute. So yeah, I don't know what's going on here. I mean, will we see similar cases like this? This is a pretty big deal. And I don't think that the Supreme Court's composition changing, if President Harris gets in there and replaces some justices, I don't really see this being overturned or anything. And I'm curious where the 6-3 conservative court is going to draw the line and say, no, this statute is actually criminalizing status. It's criminalizing homelessness. How much more harsh and explicit would that statute, or that ordinance in this case, but also it could be a state statute, need to be considered analogous to Robinson versus California? That's part of the problem. See, usually the majority opinion tries to actually respond to all the dissent's points, but they didn't respond to what I think here is the most crucial point, and that is the status nature of it. Something that defines homeless people is that they kind of just have to sleep in public, and they just ignore that. So yeah, the Supreme Court is really whack. Who knows where this will go? But yeah, I thought I would do a little brief on this, a little case brief for you all so that you could understand the case. I know we're a little while out, but if you found this video insightful, helpful, please leave a like, comment, and subscribe. I would really appreciate it. Help grow the channel. Thank you so much. And I look forward to talking to you in a future video. Till next time.